All right, the very last sections of the book that we're covering deal with opinion testimony, first by lay witnesses and then by expert witnesses. And then Thursday we're going to cover my favorite material, which is the scientific and technical evidence materials. But in this video lecture, I'm just going to be talking about lay opinion testimony, which is covered by Federal Rule 701. So starting with lay witnesses, we have to actually consider the threshold question of, well, why do the rules of evidence generally prohibit the giving of too much opinion testimony by lay witnesses? So these are not expert witnesses, just regular old witnesses. Because certainly in our everyday life, we all sit around giving our opinions on things all the time. I'm a case in point. I've certainly given lots of gratuitous opinions in this class over the course of the semester. But the main reason for not wanting lay witnesses to testify about their opinions is that it invades the province of the trier of fact, right? That's a major pillar of our justice system, that jury members or a judge conducting a bench trial should hear the facts and then come to their own conclusions. So that McGuire piece that you read on page 783 likens this ban, this general ban on opinion testimony, to the ban on hearsay testimony. So he makes the connection in that piece that both hearsay and lay opinion are somewhat suspect forms of evidence, right? They both lack a solid, sound basis for admission. In the hearsay context, the declarant is often unavailable, right? So the trier of fact can't verify that hearsay declarant's reliability. And here in the lay opinion area, the witness has drawn a conclusion from facts and perceptions based on his own experience. So that's not really subject to verification either. Even though, on the other hand, there's certainly an argument that opinion is different from hearsay in that the witness drawing the conclusion is always available for cross-examination, right? By definition, the witness is on the stand. So if a witness says the defendant was drunk, this opinion can be subject to close scrutiny on cross-examination to find out what that's based on. But let's think about that for a minute, because you have to consider whether there can really be an effective cross-examination of lay opinion testimony in this context in particular. For example, the witness is allowed to state her opinion that a party to the litigation was drunk on the night certain events happened. You know, there's certainly a line of argument that says, look, if we don't let the witness testify to this opinion that the person was drunk and instead force her to make, just talk about what she saw, like, well, he was staggering, well, his eyes couldn't focus, and so on, that makes her testimony less forceful and impactful than if she was just allowed to state her perception that the person was drunk. But from the other side, how would a cross-examiner refute that conclusion? Probably the only way would be to break that conclusion down into its component sense data. What did you see? What did you hear? What did you smell? Was the person staggering? And so on. It's going to be very tedious, takes a lot of time. Plus, this places a big burden on the cross-examiner of examining a witness who might get the lawyer and her client into even deeper trouble than just allowing that shorthand opinion, right? Because a cross-examination could just end up making the drunkenness claim seem even more plausible by going into minute detail about it. Now, with regard to this specific kind of opinion statement that someone was drunk, we're going to see in a minute that this is generally one of the shorthand opinions that is commonly allowed in court because it's a kind of opinion statement that most people are familiar with. But generally, you should just keep in mind when looking at Rule 701, there is this tension and concern about opinion testimony from lay witnesses, and this concern has always been with us. It's going to be closely scrutinized by opposing parties and courts. So here is Rule 701 covering opinion testimony by lay witnesses, telling us that any opinion statement made by a non-expert witness has to be rationally based on the witness's perception. It has to be not based on scientific or specialized knowledge, i.e., this is just regular person, everyday common knowledge. And it has to be helpful to the fact finder, to help the fact finder understand the witness's testimony. Here's an interesting hypothetical to illustrate how many things in everyday speech and in courtroom testimony really are opinions if we break it down. So suppose in the spring of 1998, the House of Representatives established a committee to investigate President Clinton's competency to hold office in contemplation of beginning impeachment hearings. And suppose a former classmate of Clinton's at Yale Law School comes to that hearing and testifies to having seen Clinton inhale marijuana. Is that an opinion? Would Federal Rule 701 have allowed this testimony in federal court? Probably what he saw was Clinton sharing a hand-rolled cigarette with several other people. He might have even smelled the smoke, believing it to have smelled like marijuana. Of course, the fact that it smelled like marijuana to him, also an opinion, right? Would that be based on specialized knowledge? Not everyone knows what marijuana smells like, as opposed to, say, just the smell of smoke in general, which I would say is a more common everyday smell that people can understand. But in any event, if we were to have overly strict requirements that witnesses should only be allowed to testify to those smaller component parts of their observations about everything, that's obviously going to end up robbing testimony of a lot of its meaning. It's going to be incredibly awkward and take a lot of time. So it's very difficult to restrict lay witnesses from stating any opinions or conclusions, even though it's sometimes hard to find the line dividing necessary opinion from impermissible opinion. I think the list of examples on page 790 of your book very helpful in illustrating this concept of lay opinion shorthand type testimony that is often, if not usually, allowed in court. Under this rationale that it would be very difficult to testify about these issues in another way. So these are the kinds of things included under the category of what is sometimes referred to as necessary lay opinion testimony. So let's go over them. Matters of taste and smell. It smelled like gunpowder. It smelled like smoke. How about statements about another person's emotions? He seemed nervous. How about vehicular speed? He was going very, very fast. That one may be a little more suspect. Certainly a cross-examiner is going to want to go after that one if it's allowed. Voice recognition is another one. I've known Clyde Bushmat for 15 years. I'd recognize his voice anywhere. It was Bushmat's voice. Probably not going to make that person break it down to, well, Clyde's voice is very low and the voice on the phone was very low, that kind of thing. How about a statement about a witness's own intent in the past where it is relevant? I was planning on crossing the street right before I viewed this accident. Next one, the genuineness of someone else's handwriting. That's my wife's signature. That's not going to be probably required to be broken down. Well, I know because my wife always writes her L's in a certain way, that kind of thing. Another one, the genuineness, the statements about somebody else's irrational conduct. He was acting like a crazy man. Now, that's the kind of statement that can be sort of an inflammatory statement. I think that would be objected to by the other side. On the other hand, I think some judges might even allow that, allowing cross-examination about what exactly that person means. And then the last one, statements about intoxication. The man was drunk. We've already talked about that one. So certainly, like I said, with regard to all of these, the opposing party can cross-examine if the lawyer thinks the testimony is iffy. But things like this often going to be allowed on direct exam. So if you see something like this on an exam, a statement like this being made by a lay witness, you should definitely pick up on the possibility that this is potentially a lay witness testifying as to an opinion and discuss that. If the testimony seems like one of these shorthand type situations, it would probably be allowed, even though it is technically opinion testimony. Okay, so you read this case, Commonwealth versus Holden, on page 785. So the Holden dissent here is in most evidence casebooks because it's such a great illustration of the classic dangers of lay opinion testimony. So unlike George Zimmerman, the disgusting cold-blooded murderer at the center of this slide, and yes, that is my lay opinion on that. But so unlike Zimmerman, Holden in this case was convicted of first-degree murder. So Holden gets arrested and gives police the alibi that he was with Ralph Jones at the time that the murder happened. Jones then was picked up by police, questioned by the police in front of Holden, and Jones denied he had been with Holden at the time of the murder. But during the questioning of Jones, Holden apparently winked while facing in Jones's direction. And it seemed from the facts of the opinion that maybe Jones didn't even see that wink, and it was in fact the interrogators who pointed it out in the first place. So there's even here in this case a question of whether Jones had any personal knowledge at all of this supposed wink. But at the trial, Jones testified to the wink having happened. When the prosecutor then asked for his interpretation of the wink, he just testified that he didn't know whether it was a wink or just Holden had something in his eye. But he was then apparently impeached with a prior statement that a detective had put into his notes, which in and of itself is a little suspicious. But that statement is there on page 786 of your book. I think he was trying to get me to make an alibi for him to cover up some of his actions, and I don't know nothing about any of his actions. That was the statement. The trial court allowed that statement to be introduced to the jury as a prior inconsistent statement, inconsistent with Jones' trial testimony. So it's kind of doubly outrageous here because Jones did not testify at trial that he interpreted the wink in any particular way, and the other statement came essentially from the cops in the case. So to even call it Jones's lay opinion here, a big stretch. But the majority of the Pennsylvania Supreme Court, as you saw, affirmed without even considering the propriety of the evidence, or at least without mentioning it in their opinion. And Justice Musmano's dissent, very forceful here. He says, not only might the wink have been unintentional or non-communicative altogether, but that no one conceivably could have known what it was intended to communicate, even if it had been purposely executed with the intent to communicate something. So it's clear that allowing in this opinion statement was error, notwithstanding the opinion. In this case, just like in a lot of others in the lay opinion area, the question presented really boils down to whether the expression of the witness's opinion should be allowed on the theory that cross-examination provides a sufficient opportunity for refutation of that opinion. Clearly, in a Holden-type factual scenario, cross-examination is not going to do the job. The very fact that the court let in this statement indicating that Jones, or in truth really the interrogating officer, detected communicative intent in Holden's wink means the court is essentially giving its stamp of approval and saying that Jones or the officer was somehow peculiarly able to know what was being communicated. But now think about the cross-examination. A witness like this is not going to be able to explain this interpretation in terms of component sense data, right? So any cross-examination is just going to elicit comments like, well, I could just tell that's what he meant by the wink, and probably also allow the witness to maybe even say more opinion-laced damaging statements. So a pretty outrageous case here. All right, so again, Federal Rule 701 and California Evidence Code 800, which is on the next slide, both provide that a non-expert witness may testify to an opinion if it is rationally based on the perception of the witness and it's helpful to a clear understanding of the witness's testimony. And again, Rule 701 also requires the opinion not be based on specialized knowledge that requires expertise. And this part was actually added after the Daubert case that we're going to cover Thursday to make sure that proponents didn't try to sneak in expert opinion under Rule 701 to try to avoid the limits of Rule 702 in Daubert, which requires that the judge determine that expert testimony is reliable and valid before allowing that in. Like I said, the California Code also includes the basic rule that a lay witness has to be testifying about things he or she perceived when giving an opinion, and not something that takes any expertise to analyze, and also that it be sort of necessary and helpful to a clear understanding of his testimony. I think one interesting way of viewing the lay opinion rule is to view it as a rule of preference instead of maybe just a simple exclusionary rule. So under this concept, the best evidence to present to the trier of fact is going to be the most concrete evidence, evidence that has as little inference added by the witness as possible. And an opinion can be almost as concrete as just a statement of facts if it embodies the most specific possible manner of describing the witness's perception, right? If it's the most specific way that makes sense. For example, this classic example, if the witness testifies, "I smelled smoke." He's clearly testifying to an opinion, yes, but just as clearly, his opinion is, if we think about it, probably the most concrete way of relating this perception, because how else would you describe smelling something that smelled like smoke? So this rule of preference implies a couple of things. First, it implies the rule of necessity. If the only way evidence can be presented to the jury clearly is through an opinion, obviously that must be the most concrete way of presenting the evidence. And secondly, the rule of preference implies that ideally a lawyer should structure her questions to a witness in such a way on direct as to elicit from him or her the most concrete possible testimony. One interesting thing to consider is, well, what do we do when a hearsay statement contains an opinion? The difficult thing about that is that, of course, it can't be reformulated to increase its concreteness and specificity, right? Because if a hearsay statement, an out-of-court statement, is going to be used at all, it has to be introduced exactly as it was uttered, exactly as it was said. So because of that, since we can't improve the declaration, we have to just take it or leave it. In the admissions area, what are now called statements of a party opponent, courts usually admit these statements even if they have opinion in them. Of course, they are exempted from hearsay, so they get in under the hearsay rules despite being out-of-court statements admitted for their truth. But when they contain opinions, they still are usually not barred by Rule 701. So effectively, it's held that the rule against lay opinion doesn't apply here because by definition, the declarant is a party, and that party can always explain what she meant, be cross-examined about what she meant if it's less than clear. But in other contexts, the traditional practice of courts was that most courts would not admit clear opinion in a hearsay declaration that was only going to be admitted through an exception. However, the modern trend is definitely changing that. More opinion type hearsay is getting in. And a lot of people think this is the way it should be because sometimes an opinion in a hearsay statement may really help the jury in determining what the declarant observed there. Okay, the last thing we're going to go over now in this lecture is the Government of the Virgin Islands versus Knight case on page 788. Really interesting case from the Third Circuit, 1993. So the defendant here attacked the victim with the butt end of a pistol, and while in the process of beating him with the pistol went off and killed the victim. So the defendant wanted to put on testimony from an eyewitness at trial and testimony from the investigating police officer that in both of their opinions, the firing of the weapon here was an accident. But the trial court excluded both witnesses' testimony as inadmissible lay opinion. But as you saw, the Court of Appeals here held that the eyewitness's opinion at least should have been admitted, although they do say the error was harmless. And they were right here about the harmless error analysis because, in fact, no one involved in this case or in the trial, including the prosecutor, really doubted that the gun went off accidentally. So it was really about convicting the defendant of voluntary manslaughter here anyway. But the opinion here says that the opinion statement of the eyewitness should have been admitted because it's otherwise really difficult to articulate all the reasons why that eyewitness would have concluded that the firing of a gun was accidental, aside from just saying, well, what do you think? Did it look like it was accidental? I think the opinion here does a great job of applying Rule 701, finding that both elements in A and B were met here, rationally based on the witness's perception and helpful to understanding the testimony. The witness had firsthand knowledge, and certainly describing the fact as an opinion would have been a helpful way of making it clear to the jury why this witness thought the gun went off accidentally. The Knight case is also a good illustration in support of the modern approach to lay opinion. Although the testimony offered was undoubtedly opinion, it would have been helpful to the jury, was certainly a lot less speculative than the testimony about the meaning of the wink in Holden, for example. So this might be included in the kinds of opinion testimony considered to be necessary. But in contrast here, I just want to contrast that with a car accident case and maybe a passenger testifying that the defendant was driving carelessly. Here, this witness easily could be asked to go into the particulars of why, in her opinion, the driver was driving carelessly, to talk about, the speed, maybe looking at the speedometer and seeing how fast the person was going, and, was weaving around on the road, that kinds of things. So in this case, a witness shouldn't be allowed on direct to use this word carelessly when describing the driver's driving, as opposed to the example in Knight. But getting back tonight, you did see the court found that the trial judge had correctly excluded the police officer's testimony and conclusion that the shooting was an accident, since he was not an eyewitness. And this ruling is clearly a correct ruling. This officer had no personal knowledge. The jury should be the body that draws conclusions from secondhand evidence. But I do have on the bottom of this slide, well, what if the officer had been qualified as an expert on investigation of assaults? Could that evidence then have been admitted as expert testimony? Now, in an assault case, I think it would be difficult to convince a judge that the jury needed the assistance of expert opinion. But in drug cases, organized crime cases, gang cases, even sometimes car accident cases, the opinion of these supposed police officer experts who lack personal knowledge of the case is often received after qualifying law enforcement officers as experts, even though a lot of their testimony here is just plain hooey and made up, so that they really shouldn't be qualified as experts, yet they are in many, many cases. And we're going to talk more about police officer expert testimony in the Odom and Scop cases. Okay, that's the end of this video lecture on lay witness opinion testimony.